Now coming to the second question. I am of the view that the appointment made on a post which is not in accordance with law would not confer any right upon the incumbent either to hold the post or to continue in service on such post in any manner. Mere length of service or lack of any fault on the part of the employee concerned is not relevant in as much it is the observance of statutory provisions and not the personal or individual act on the part of the parties concerned which would decide the rights of the persons to hold the post. If a person does not possess the requisite qualification or is otherwise appointed on a particular post in violation of the statute, he cannot claim to have a right to continue in service simply because it has worked for a long time for the reason that estoppel does not apply against statute and any appointment against the statute is void ad initio. Even on the ground of sympathy, no such relief can be granted since a court of law is primarily concerned with rule of law consistent with constitutional provision, and mere sympathy which is directly against the statute and constitutional provisions would be a case of misapplication of the understanding of principles of equity and justice. It would be difficult to hold that an action which would be contrary to statute has the effect of violating others' fundamental right of equal opportunity of employment can be equitable and sympathetic thought it is otherwise unconstitutional. A sympathy or equity which will result in upholding illegal and unconstitutional orders or acts cannot be considered to be within the four corners of principles of administration of justice in equitable exercise of power under Article 226 of the Constitution. It would be a travesty of justice if we allow the concept of sympathy or equity to influence the mind of the court even when the action is ex facie illegal and unconstitutional violative of Article 16 of the Constitution. Recently, the Apex Court has declined to grant any relief to a person merely because it has worked for a long time, though did not possess requisite qualification at the time of appointment in accordance with rules and the appointment is not in accordance with the procedure prescribed. Now coming to the third question, it is no doubt true that before passing the impunged resolution and giving effect thereto, no opportunity has been afforded to the petitioner by issuing a so-called notice, but the petitioner has been given extensive hearing before this court to show whether her appointment on the post of assistant teacher junior high school was valid, and the arguments at length have been heard. In view of the discussion made above, the only conclusion possible in the case in hand is that the appointment of the petitioner on the post of assistant teacher junior high school was in the teeth of the statutory rules and cannot be sustained.